Therefore, untrained candidates do not deserve any justice or equity. Their termination is the right course of action. And following action, what should be done? That was the basic premise. The judgment of the Honorable Single Judge has two categories. I am not touching the trend, clearly said. Irrespective of the fact that interview, taste, whatever, though I have all my independent points that this is just a perception, not correct. Irrespective of the fact, everything was in the similar manner. But because at the time of recruitment, under Rule 6.3, I was an untrained candidate.
Yes.
Admittedly.
Yes.
So that was the premise of the Honorable Single Judge to make a distinction between trained and untrained.
How does that affect you?
Yes. If I put
you are also untrained.
I am untrained,
yes,
but I am no more untrained after 19th April 2019. That is the law of the land declared by the Honorable Supreme Court after setting aside the judgment of our court.
It's not the ground of the cancellation of the appointment.
Exactly. That's my
Then
point.
why you are arguing that?
I am arguing because the writ petition was not filed.
Petition said that I am untrained.
Yes.
You are untrained.
Yes.
You have been favorably dealt with by the board.
But when the writ petition is saying so,
that was in September 2020.
Yes, that
now whatever right crystallized in your favor, we are not on that. You are asking us to examine whether the direction for cancellation was justified.
Absolutely. Kindly look at this way.
So please make it within those parameters.
I am coming to that. Kindly see that. This is most likely, unless I'm missing, either I'm missing completely or there is such a fundamental point which has been missed completely by the, allow me to reframe it. All I am saying, by virtue of the Honorable Supreme Court judgment, which is the law of the land, kindly forget it that I understand this law of the land was declared in April 25, but Lordship is hearing today. Lordships may not ignore this judgment. And this judgment, Supreme Court clearly held that by 19th April, I ceased to be an untrained. I was surprised when I read it. That was my first reaction. I know I'm doing something like adventuring because this point was never been there. Of course, it was never been there. But
now, then what is the analogy? Then after April, what is your character?
Yes. After April, if I fulfill those three conditions, the condition number one, that I have to be in service by August 2017. That's the Honorable Supreme Court held. Condition number two, during service, I have to complete that through NIOS only. And third condition is, I have to complete that course by 19th of April. And thereafter, the Honorable Supreme Court said, anybody who is not fulfilling or fulfilling only one condition of fulfilling after April 19, he will not get this benefit. Effect is after April 19, because of the fulfillment of these three conditions, declaration of the Honorable Supreme Court is, you become at par with the trend. That is what Rule 6.3 of ours. Or I would have faced the dismissal. Now this declaration,
have they made this point in their writ petition?
No, why they will make? They will not make it. I say that, kindly visualize this way. They filed the writ petition in September 2022. Now in September 2022,
your contention is by the cutoff date, I have now become a trained candidate. I have been appointed. Untrained cannot disturb my appointment because now at this juncture I am trained. That is your argument.
Yes, plus by the same judgment, the Honorable Single Judge has said, I am not touching trained candidates who were trained at the time of recruitment.
Yes.
Now,
all right, your argument is by the cutoff date I have become trained. You cannot challenge my appointed now in this course, in these facts.
By telling me that you are an untrained, all I'm trying to say that had the writ petition being filed before myself become,
Which paragraph you are
yes,
showing?
paragraph 26, 3 paragraphs. Kindly see 26 first.
Yes.
Well, this is, Lordship has got 26.
Yes.
It can thus be seen that this court observed that since the time gap between the direction issued by the central government and 31st March 19 was only about 18 months, the period of the course was reduced from 2 years to 18 months. It can further be seen that this court recorded that around 12 lakhs, such and such, in-service elementary, in fact, we also fall under 12 lakh, elementary teachers had registered and made payment on the NIOS portal as on 30th September 17. Not only that, but this court also observed that the NCT recognition order dated 22nd September 17 was, kindly mark this, only for those untrained in-service teachers in governmental aided, unaided private schools who were appointed or not before this condition, 10th August 17. So anybody after 10th August, no. Pertinently, this court observed that the entire scheme was for the purpose of providing a window to the in-service teachers in as much as unless they would have acquired requisite qualifications prior to 1st April 19, they could not have continued to remain in service and would have faced dismissal. Kindly thereafter see 33. Or before 33, sorry, paragraph 28, last sentence. Writ petition would be attracted under that. Because there is a direction by the Honorable Single Judge, hold another examinations, giving them time to do the training, which is completely contrary to 28. 28, last sentence. Any other candidate who was not in service as on 10th August 17, that is writ petitioners, cannot be considered to be at par with the 2 years DLED. Kindly come to 33 thereafter. As observed herein before, as observed herein before, it is clear that the judgment of this court in the case of Jaivi Singh unequivocally held that the entire scheme emanating from the NCT recognition order dated such and such was for the purpose of providing a window to the in-service teachers in as much as unless they would have acquired requisite qualification prior to April 2019, they would not have continued to remain in service and would have faced dismissal from service. As such, this is the condition. Any teacher who was in service as on 10th August 17 and who acquired the qualification of DLED by way of 18 months program through NIOS prior to 1st April 19 is a valid diploma holder and at par with any other teacher who has been completed the 2 years DLED program. My respectful submission is this. Had the writ petition been filed prior to 19, no difficulty.
Have you taken? You couldn't have taken this ground in the appeal.
But that is.
You are now going beyond that.
Your Lordship.
New points.
Yes. Your Lordship.
This is not the subject. You have not taken this ground in the appeal.
May I say this? Would your Lordship genuinely think that I should not take this point? Then I will not say any single word.
That is choice is up to you, Mr. Dhar. You are arguing something
which
was not there.
May I say this?
Not even there in your appeal.
No, that is there. May I say this?
Where is it? Which was one ground that you had a premeditation that Supreme Court in future years will decide.
Kindly allow this. Kindly allow.
Unnecessarily elongating the issue.
This is not unnecessary.
This is because that is one say you are saying your writ petitioners have not pleaded anything and they are taking this.
May I say
now you are saying that no, though I have not pleaded, I will take this.
No. Kindly allow me to say what I'm.
We have allowed you come to the next point.
But I will come, but I have not finished this point. Lordship,
we understood.
But I am not join the practice for 1 year and I will take all the irrational things. Lordship is dealing with the lives of about 2 lakhs persons.
Please don't remind us of our duty and obligation.
So kindly,
We have put you a question, you have failed to answer that. But still, we have heard you on that point. You proceed to your next point.
I'm answering to Lordship's query. Lordship's query whether I have taken this point or not. Kindly see the date of the judgment. Yes. It was of April 25.
You could not have taken.
So therefore, we don't have a time machine.
So then why you
were not even parties? Point? Kindly look at this way. No, Lordship, this is unfair. I was not made as a party. I had to go before the Honorable Supreme Court. Supreme Court directed that all contentions have to be made. In the meantime, Supreme Court declared a law. Lordship do not want to see it. Can this be a law? Can this be a law?
What we are doing?
My interpretation, kindly see, my interpretation may be wrong, but to tell me, go back to the time machine, this judgment was delivered in April. I am trying to get the benefit of the judgment.
Don't misquote us. Yes. This point you raised on the earlier occasion also. We said, Mr. Dhot, please restrict yourself on the basis of the materials which are there. You insisted that I should put this point. You have put your point. We have taken note, finished. Come to the next
I point. Have taken this point in a sense that under 6, can you take the rule, my lord? Can you take the rule itself? Because this is not that something new has come up by the Supreme Court. It was there very much part and parcel of the rule. Every time, my endeavor is this. Kindly, my lord, I may not be able to, my lord, express myself. But my endeavor is this, that once a litigation is filed, then rights of the litigators is of that date itself, and that is 22. And the window created by the Supreme Court based on the NCT several orders, that window is finished by 19. Now, right before the learned single bench, this judgment was not there because there was a contrary view in present. But today, all over India, every teacher who are appointed and fulfilling these 3 conditions, they are treated at par because of paragraph 33.
We understood you.
And
what more do you have to
now, Lordship, may kindly look at this. Kindly see this.